Dear students, I welcome you to this brief lesson on section 1. So this is section 1 as you can see in the Bare Act. Now, when you look at the first heading of the short title in section 1, what the short title tells you is as to what the name of the Indian Evidence Act is. So you know that this is called the Indian Evidence Act because the short title says so. So for example, you might have a question, why couldn't this statute have been perhaps called the Code of Indian Evidence? Well, there are many reasons for that, but one of the reasons is that, well, it has been named the Indian Evidence Act. So that's what the short title tells you. The next heading that you see is that of extent. I will deal with this in a little more detail ahead, but for the time being, let me just tell you that it talks about the territorial extent, which means as to which territories the Indian Evidence Act applies, and then it also talks about the matters to which it applies. Right? So as you can see for the time being, it extends to the whole of India. Alright. So prior to the amendment of 2019, it extended to the whole of India except the Jammu and Kashmir. But as of now, it extends to the whole of India. Now this third heading here is quite simple. What the commencement of the Act tells you is as to when the Indian Evidence Act came into force, and it came into force on the 1st of September 1872. So as I said a little earlier, we will be seeing this middle heading of extent in a little detail. We've already seen that it extends to the whole of India. Now I want to draw your attention towards this little part where it says that it applies to all judicial proceedings in or before any court, including courts martial. Well, so the Indian Evidence Act applies to everything, including a court martial. That's the first important thing. So it applies to judicial proceedings before any court, and that includes even a court martial. However, there is one kind of court martial that is excluded, which is what you find in the later part. So for example, I will now highlight this part. These are the kind of court martials which are not brought under the purview of the Indian Evidence Act. So to understand that, basically what you should say is that the Indian Evidence Act extends and applies to all judicial proceedings in any court. It also applies to courts martial, right, as a general rule. But then, if a court martial is convened under the Army Act or under the Naval Discipline Act or under the Indian Navy Act or the Air Force Act, then it will not be applicable, right? So if a court martial is convened under these, it will not be applicable. Let me now take your attention to another important word here. It says that the Indian Evidence Act does not apply to proceedings before an arbitrator, which means that in arbitration proceedings, what you basically have is two parties who are not necessarily arguing before the court. So an arbitration is a little different because you have two parties who now come and have this arbitrator who tries to resolve the dispute between the two parties. This is meant to be an alternative method of dispute resolution. It is meant to be expeditious, which means it is meant to be fast, and therefore it does not require that the procedural rigors, the procedural requirements of the Indian Evidence Act be followed. Therefore, the Indian Evidence Act does not apply to proceedings before an arbitrator. Finally, I talk about one more important word, which is that of affidavits. I will be dealing with affidavits with you in detail as we go ahead. But for the time being, let me just tell you that when you have a fact could be proved either by adducing evidence or it could be proved through an affidavit. An affidavit differs from evidence in one very important respect. Let me tell you what that is. Let us say A wishes to prove a certain fact. Okay. If he is to give an affidavit, then in an affidavit, he swears. So A basically swears that I am saying the truth or that I know this to be correct. So basically in an affidavit, A himself gives proof of that fact, right? He himself gives an affidavit to substantiate what he himself is saying. It's like I say that I am right, I am being honest. Well, it's different for evidence. If A were to prove a fact by evidence, right, In that case, he would have to get another document from somewhere else. He would have to get a witness, which is why you have either documentary or oral evidence. This is why evidence is different from an affidavit, and the Indian Evidence Act does not apply to affidavits. Now, I just said that the Indian Evidence Act does not apply to affidavits, but that doesn't mean that affidavits are not a part of the law of evidence. You see, if you talk of the law of evidence, it could be included because the law of evidence is not just the Indian Evidence Act but also includes other statutes. For example, it includes the CRPC and it includes the CPC. While you do not need to study affidavits in detail for your present exam, I'm just showing you that the word affidavit finds itself mentioned several times in the CRPC. So what I've done right now is that I have done a control F, a search for affidavit, and you see that the word affidavit is used several times in the CRPC, right? And we will study these eventually. You don't need them for the time being. Take for example section 296. It says that evidence of formal character may be given by an affidavit. So we shall study this later. You need not bother about it right now. Likewise, what you see here is a control F that I have done on the CPC, and you can see that an affidavit has been spoken of several times even in the CPC. Therefore, the law relating to evidence can also be found in the CPC, and we shall discuss that later. With this, I hope I have been able to bring some amount of clarity regarding Section 1 of the Indian Evidence Act. God bless you.